statutory construction.
Mr. Vasoot.
Thank you, Mr. Speaker. Members, House Bill 113 amends the Code Construction Act and the Construction of Laws chapter of the Government Code to ensure that the laws passed by this body are interpreted according to their plain and ordinary meaning and not based upon legislative intent. I move passage.
Mr.
Ms.
Speaker,
Rodriguez-Ramos, for what purpose?
would the gentleman yield for some questions?
Gentleman yield for questions.
will yield for questions.
He yields for questions.
Thank you, Representative Vasoot. In reading your bill, I find it honestly a little alarming. On page 1, could you talk a little bit about intentionalism prohibited? So what does that mean in terms of the everyday operations and the practices that we partake in as we're here on the House floor discussing and debating different legislation?
So I'd say in general terms, what it means is when we pass a statute, the court is to interpret the statute according to the plain and ordinary meaning of its text, taking into account all of the definitions that we put into the statute and where they're placed and all the cross-references, but not to look at the back microphone, not to look at the bill analysis packet, not to look at some hidden meaning of maybe what somebody said on Twitter, maybe one out of 150 of us, what they thought it meant, but rather what the words mean in the common English tongue. And that ensures, what it's really about, is that ensures that the lawmaking power is vested in the legislature and not in the courts.
Well, and I understand what you're saying, but it says use of legislative history prohibited. So when interpreting a statute, a court may not consider, consult, cite, or rely, or give any weight on any statement that any individual legislator says, or a statement by the author or the sponsor of the bill. So then, if that's the case, what would be the whole point? Are you proposing that we change our whole practice here, that there is no point in us even debating a bill or even really being elected and coming to the House floor to discuss bills because we're not allowing the courts to use anything that we've said to interpret a statute? So how does that work in your proposal here?
So through the legislative process, when the bill is filed by the author and they go to the committee, what the author intends and thinks and is trying to do is relevant for the committee in making a decision about whether to report that bill favorably, unfavorably, or not at all. Once the committee reports the bill and it comes to the House floor, the bill analysis provides the members of this body information about the bill, what it does, what the author was trying to do, so that we can make an educated policy decision to make an educated policy decision about whether or not we want to enact that law or we want to amend it. And once we pass the bill through here, of course it has to go through the Senate. And so the Senate's going to look at the legislative history and determining whether or not it wants to pass the law. And then once the Senate passes it like we have, or there's a conference committee and we both adopt the report and it goes to the governor's going to look and have his team looking back at all of the discussion on the bill and everything in the packet to determine whether to sign that into law. That's relevant for those purposes, so it doesn't change that process, but what it changes is when the ink hits the paper and that becomes the law. It is not for the court to go back and say, well, Representative so-and-so said this at the back mic, so that must mean it must mean what they thought it meant. Or so-and-so over here said it. Because you're picking, people out of a hat. Or you're putting into, you're giving more power to an individual member of the legislature rather than what we collectively passed into law. And so to your question, no, this does not render what we do on this floor meaningless. It's still very meaningful. It just ensures that when we ultimately pass legislation, that the courts give it the effect of the words we chose to put on paper. So the burden is on us to make sure we get it right.
Well, you would agree a picture is worth a thousand words, right? Looking at something, you're able to understand or interpret what's actually happening versus just reading an article. You get different interpretations based on what you see or what you have access to. And as you mentioned, the debate here that we have engages and informs and educates our peers as to the intention of the bill and why the legislator drafted something. And we're afforded that opportunity because we have this dialogue, which will establish more of a basis of the purpose of that legislation. And I think it's really important because not only do we get educated, but the community, the populace gets educated as well. And we share that information with the Senate, and the governor takes that into account as well. We're closing that off when we take it to the courts because they are now we're saying, no, all of these endless hours that we spent parsing out words and making sure that we understand the intention of what the legislator, we're wiping that all away and saying, okay, courts, don't listen to what we've said these past 6 months. Look at the black letter text, simply that, and then now we're asking the court to make their interpretation based on words that they really don't even have a foundational basis for because they're now prohibited from going back and doing their research on what the intention is. And is that what you're proposing to do, that closing it out so that the courts are not able to use anything that we're talking about here?
What I am proposing is that when the legislature speaks, that action occurs through the passage of a bill, not questions and answers from the microphone, not what is in a bill analysis report, not what we put into the journal, but what we decided to underline and strike through in law. This is the legislature speaking, not while you and I are having dialogue that informs the vote on this bill and is important for that purpose. This is not the law. The law is what we pass. And that's when the legislature speaks, is through the law. And the courts should be tasked with upholding the law passed by the legislature. That's really what we're getting at.
Right, but the legislature speaking is also the legislature speaking, the legislator speaking. So if I have a law that says one thing, but I'm here on the microphone espousing all of these anti or these racist statements or whatever, and that was the intention, but I'm not going to get that written down in the law, but just know this statement that I say means this on the paper, but I can now be on the mic for hours and talk about another completely separate agenda, but the goal, my agenda is over here, but I'm going to make sure that I write those statements to separate that. We're saying that the judges, the courts can no longer use the debate, the conversations. I could be on the mic and say this bill is really intended to kill a lot of people, but now the courts can't say when we're interpreting that law that the legislator's intent was to kill all of these people, because I didn't write that in the law, but that was my intent. So that's what we're saying in this bill, that we're allowing that to happen, correct?
I would disagree. I think to your point about why you may believe someone has filed legislation or pursued legislation is oftentimes a subjective analysis. Maybe it's informed by statements that you make at the microphone if somebody admits to something. I get that. But a lot of times it's just what we may view. Like I may be thinking about what you think, and you may be thinking about what I think, but we're not expressing it. And all a court is called on to do is to enforce the law that we have passed and to adjudicate cases and controversies under that law. And so regardless of what somebody intended, the law is to be applied. And if there's a problem with the law, if we wrote something, that we should have, or the program's not good, then that is our responsibility to fix it when we speak through the law.
Okay, another question I had, because this bill not only prohibits us using the courts using our words in the work that we do other than what's written on the paper, it also explicitly prohibits courts from deferring to state agency experts who, for example, know how environmental rules are or worker safety standards function in the real world. What's the reasoning behind forbidding courts from deferring to subject matter experts who work day in and day out and who've dedicated their careers, their studies, their education, their professional lives on working on safety standards? Now we're saying that the courts can't even defer to those agency experts.
Well, what we say is they're not required to, but even so, the prohibition doesn't prevent the court from giving the construction of a statute that an agency does if that construction is reasonable and does not conflict with the plain language of the statute. Because when we're giving agencies authority and they're interpreting a statute that we pass, they should not be interpreting it in a way that is different from what we've said. Because agencies are not the lawgiver, the legislature is. And so all of this is about making sure that the people's elected representatives, and not a bureaucrat, not a judge, says what the law is. And if we have an issue with, how a law is applied, or whether we think maybe this law doesn't go enough to address this environmental concern or otherwise, the people go to their members of the legislature and advocate for them to change the law. And that's how we address it, rather than, for example, coming up with some interpretation of the law that conflicts with it.
Right, and I understand agencies do not create the law, but I think if sitting in this body today, it would probably take us more than 6 months just to tackle one agency, right? For us to do what HHSC does, or what any other agency that the EPA does, or what have you, it would take us more than 6 months to do that. It would take us years just to tackle one agency. So we depend on the agency to provide those experts, to provide the know-how to guide us in how we're going to implement these laws.
May I address,
Yes,
I think
sir.
maybe where you're going with that. So nothing in this prohibits the legislature from delegating authority to the agencies. Nothing in this prohibits the agencies from making and exercising their rule-making authority that they already have. So when the experts are adopting rules, they can do so as long as it is in line with the jurisdiction and the instructions that they have been given by the legislature. All this does is simply say that the agency cannot interpret a statute contrary to its plain and ordinary meaning. So to your point about deferring to experts, yes, there are experts in a variety of fields. I don't know anything about airplane mechanics, so I'm gonna defer to an agency on perhaps some of those granular details. But the agency is going to do that pursuant to the authority we have delegated them, not exceeding that authority by interpreting the statutes contrary to their plain and ordinary meaning.
Now, if the courts second-guess every agency decision, won't this create chaos and uncertainty for the very Texans who need reliable guidance? And how will this affect Texans relying on clear agency rules, like small business owners or families navigating healthcare programs?
Great question. So this is actually good for business, because what this says to business is when the legislature passes a law, that's what they're going to have to abide by, as opposed to some hidden meaning or intention that might be grasped onto by a judge. So they'll know when they look at the statute, that's the playbook that they're having to operate under. To your question about the agencies, the same is true for them. If we've delegated rulemaking authority and the rulemaking authority is in accordance with the jurisdiction we've given them, and they are not interpreting the statutes contrary to their intent, it's going to be very clear to business and to, I think the other example, of families,
Yes, sir.
how the law is going to work. And so on that basis, I don't see the issue.
Okay, now this is leading up to a question, so bear with me. Let me say, for the benefit of those people at home watching who may not know, after a decades-long corporate push, the Chevron deference doctrine was recently overturned by the Roberts Supreme Court. And to explain Chevron was a 1984 Supreme Court case to set the precedent that federal agencies should have the power to interpret the ambiguities in the laws of Congress. Now, this is important because Congress can't possibly legislate every small rule and regulations that we rely on our agencies to do. Taking away this deference and imposing judicial review means a judge now gets to decide for an agency how to do its job. And in the aftermath, we've seen agencies that protect our worker safety standards or environmental protections get challenged in court after every rule they make, devastating their ability to protect us. Placing the judiciary above the legislative and executive branches destabilizes the balance of our government. Is this bill part of a national conservative push backed by ultra-wealthy corporate interests to attack our rulemaking agencies that safeguard our consumers? The same corporate movement that overturned Chevron in an attempt to now bring the billionaire-backed slash and burn we see in the federal government happening now?
No.
This is not part of a conservative push?
Well, I tend to be identified as a conservative. I think it's a pretty conservative public policy. But what I mean by that is I don't mean that in the political spectrum. I think it's conservative in preserving the core traditions and functions of our government, that the people in our Constitution have endowed legislative power in the legislature, and this ensures that that power is adhered to by the courts. And so in that sense, it's conservative, not politically, but philosophically and judicially. And so, no, I would say no to the rest of your statement, but I hope
Yes,
that
sir.
I answered that fully.
Yes, sir. And last question. It really, I guess, goes contrary to 250 years of democratic norm where we're not allowed now, or the court's not allowed to look at the legislative intent. And in this practice, in this body, we often say, we want the journal to put this in writing for legislative intent, or we want that for history, right? So that we'll know what we're talking about, others will know what the intent is. So that will, I guess, essentially be unnecessary moving forward.
Well, unnecessary is perhaps a strong word. Again, as we mentioned, putting things into the journal are important for a number of other reasons, whether it is to inform our constituents, to inform the Senate, to inform the governor. But all I'm saying is it's not to inform the courts.
Okay. And last question, is this a Heritage Foundation bill?
No, it is not. I don't think I've ever worked with them. So
Thank you, sir.
Thank you very much.
Mr. Martinez,
Will
Fisher,
gentleman
for
yield
what
for
purpose?
questions?
I yield for questions.
Gentleman yields for questions.
Thank you, Mr. Speaker. Thank you, Chair Vasut. I listened to the earlier Q&A, and I just want to be clear. Are you doing anything to impact current law on injunctions
Current law on injunctions.
or current practice on injunctions?
Well, to the extent that you are seeking an injunction based off of the violation of a statute and you prove irreparable harm and all of the other factors, let's put that aside, and the baseline text, it would impact how a court interprets the statute, and the way it would impact it is the court would give the construction to the statute that was its plain and ordinary meaning.
And so, and that's sort of your intent when you write this legislation. You are trying to guide the court on how they interpret the statute to render injunctive relief?
Not necessarily. As the Chief Justice said during his State of the Judiciary, the living Constitution is dead in Texas. This ensures that kind of the concept of the living statute dies as well. The statute means what it says, not what somebody wants to give it some other meaning.
But I guess I'm saying in this proposal, in this legislation, if a judge gets past that, he or she interprets a statute and decides to issue injunctive relief, is there anything in this bill that would limit or instruct the court on how they apply the relief to the litigants?
All this bill is about is the general precepts of statutory construction.
Right.
General precepts of statutory construction and prohibiting the use of certain materials, certain aids like legislative intent. So this is general application, and if you know how this statute works, Section 311.003 Co-Construction Act, these rules are not the exclusive, but they're meant to provide the guidance to the courts. I mean, the courts, by and large, are doing this already, but it's not in statute. And so when by courts, I mean the Texas courts, the Supreme Court especially.
And I get that. I mean, all the interpretation and the construction and the intentionalism, that's all as the judge is deliberating over a controversy. But let's say the judge decides that injunctive relief is warranted and issues an injunction. Are you doing anything in this bill to instruct the court on the reach or the legal effect of that injunction? Or does...
Are you meaning, and I apologize for asking a question from the front mic, but I want to make sure I answer your question. Are you meaning in the sense that I am impacting how a court may craft judicial decrees?
I think what I mean is that once a judge decides to issue injunctive relief, are you telling the judge who that injunctive relief would apply to?
This does not amend or impair or impede the pre-existing statutes governing TROs, TIs, et cetera. So okay. I guess my answer to your question would be no, but I guess maybe I'm not following it, and I apologize for that.
I'll wait for the gavel, then we'll
The gentleman's time has expired.
Mr. Speaker, may I please extend for a few minutes?
Members, you've heard the motion. Is there objection? Chair hears none, so ordered.
And I think you're right on that, because as I look at the sections of code that you are amending, you're in the government code. Is that right?
Well, I mean, the Code Construction Act and the Construction of Laws chapter, it's interesting that that's not called an act, but the way that those work is 311 is for the codified statutes, and 312 is for the uncodified statutes. But it's statutes passed by the legislature. When the courts are interpreting those, they are to give them their plain and ordinary meaning. That's what this is about.
Right. And then because you've said, well, maybe we don't tinker with the injunctive relief, that's because it's in another section of code. If I'm not mistaken, it's in chapter 65 of the Civil Practices and Remedies Code. Does that sound right?
Well, I would tell you this. So, and it might be 65. It's been a hot minute since I've looked at the CPRC. But whatever the governing statute is for the jurisdictional limits of a court granting injunctive relief, all we're saying is that is to be interpreted by its plain and ordinary meaning, as opposed to impairing what type of injunctive relief a court grants under that authority.
And again, so we're not telling a judge how to apply an injunction. We're just telling a judge how to arrive at a decision as to whether or not to issue or not to issue an injunction.
Purely based off of interpreting the statute at issue, whatever that statute may be, and to the extent the court is going to craft a remedy, that's of course within the court's discretion.
Thank you, Chair Vasu. Mr. Speaker,
Mr. Martinez, for what purpose?
pursuant to Rule 8, Section 3, and pursuant to Article 3, Section 35 of the Texas Constitution, I raise a point of order.
Bring your point of order down front.